Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today may be the day I earn your subscription. For today's story, we are dealing with an order from the Supreme Court of the United States, smacking down the Biden administration, smacking down the CDC, saying what we've all been saying for quite a while: no, you can't do that. For some reason, the DC Court of Appeals disagrees. I read their decision. It made no sense to me. But, every other circuit that looked at it said, yeah, this doesn't make any sense. And their district court said it doesn't make any sense. And the Supreme Court surely strongly implied in its order from late July that it didn't make any sense. But that's okay. And then, of course, the Biden administration, like 3 days before they put in place the new order, revised order, on the 3rd, so this would be like the 29th or the 1st or something like that, they were saying, no, we can't do that because the Supreme Court told us exactly not to. And then 3 days later, we totally can. This makes me sad. This makes me sad for rule of law. When I hear things like that, it makes me think I don't want to ever hear from a Democrat ever again that a Republican is defying the intent of a court. I don't want to ever hear again that they are usurping judicial authority and not giving deference to the judicial branch. When the Congress and the president and the head of the CDC and presumably all their general counsels said, this is totally cool, even when it's clearly not, it makes me say to myself, I never want to hear from a Democrat ever again that a Republican is not obeying the intent of the Supreme Court order. Yeah. So anyways, before I get too high on my soapbox, let's read this decision from the U.S. Supreme Court that came down. And just by way of description, this came down in fairly fast time. As I mentioned, the revised, new and improved CDC mandate was issued on the 3rd of August. And then on August the 13th, the district court denied the motion. So that means in the interim 10 days, they filed and got a decision from the district court, right? And then on the 20th, so 7 days later, they got a decision from the DC Court of Appeals. And then 7 days later, today, they get a decision from the U.S. Supreme Court. So I don't think this is quite a record, but it's pretty close. The Supreme Court can really move when it wants to. Also, water is tasty. Let's read. This is per curiam, which means it's not issued in the name of any particular justice. It's just issued in the name of the court as a whole. How exciting. Per curiam. The director of Center for Disease and Control and Prevention has imposed a nationwide moratorium on evictions of any tenants who live in a county that's experiencing substantial or high levels of COVID-19 transmission and who make certain declarations of financial need, which has been estimated to be 80% of all U.S. counties, impacting 90% of all Americans. So it's not everyone, but it's close. The Alabama Association of Realtors, along with other plaintiffs, obtained a judgment from the U.S. District Court for the District of Columbia vacating the moratorium on the ground it was unlawful. Yep. But the district court stayed its judgment while the government pursued appeal, which is very typical and actually quite admirable from the district court. You see too many district courts, in my opinion, who start issuing nationwide injunctions, even though they're a district court. So even though they're a district court, they're suddenly issuing these nationwide injunctions for an entire nation. Because I'm so special, I can do that. I have problems with nationwide injunctions just in general. So I'm going to hold true to that principle because I try to remain principled. I have a problem with nationwide injunctions, especially when they're issued by district courts. So this district court said it's illegal, and then say I'm going to stay my own ruling. In other words, I'm not going to issue a nationwide injunction. So even though I thought the CDC moratorium was crap, because I also opposed nationwide injunctions by district courts, I thought the district court made the right decision. You see what we did there? You see what we did there? We declared a principle, and we held to it, even when it didn't favor our side. What novel concepts in this day and age? The district court produced a comprehensive opinion concluding that the statute on which the CDC relies does not grant the authority it claims. I had a hard time finding it too. This case has been thoroughly briefed twice. Yeah, the dissent is going to get into this whining about how, well, we just needed to have a full briefing. We need to have a full hearing. Now, again, I would be more inclined to agree with the dissent, but not necessarily part of the dissent, but I'd be more inclined to agree with the dissent, and possibly part of it, to be fair, if this was the first time the Supreme Court was hitting the issue, especially if it was doing it on an expedited basis. The Supreme Court should not act precipitously. So I'd be more in line with the dissent and possibly siding with the dissent if this had been the first time the Supreme Court had been considering. But of course, not so much, because the Supreme Court had considered it a mere 30 days ago. Well, yeah, about 30 days ago, give or take. They had considered it with briefing, and they've been thinking about it. So it's not the first time they're seeing these issues. So dissent is just oh, we need more briefing, we need more hearing. What you really mean, dissent, what you really mean, and this is, again, why I think the dissent is full of crap, what you really mean is we just want to buy more time. It's not like we're going to agree with you with more briefing, or even that we really think that more briefing is good in some way. We just want to buy more time for the moratorium to remain in effect. We know you're going to rule against us, rest of the Supreme Court, but we're going to pretend like what we really care about is briefing. Either A, because, we want to see more because we're not convinced yet, or B, even if we are convinced yet, we still want more briefing, because we're not going to be convinced, but it's important for the sanctity of the institution. It's important for the court, blah, blah, blah. If you were saying either of those things, I'd be more inclined. But you're saying, C, we want briefing because we want the CDC mandate to remain in place longer, even though it's illegal. You're not doing this out of some purity of the court. You're not doing this out of some ability for yourself. You're doing it to benefit the CDC. Bad motivations. And careful review of the record makes it clear that the applicants are virtually certain to succeed on the merits of their argument the CDC has exercised its authority. Yeah. It's not a particularly complicated statute. I've read worse. A lot. It'd be one thing if Congress had specifically authorized the action CDC had taken, at which point we would be asking different arguments, right? It's not necessarily the CDC action would be legal. We'd just be making different arguments, right? We're at the moment deciding this on statutory grounds. We are saying CDC can't do this because it's not authorized by statute. So if Congress authorized it, it would be authorized by statute. So we wouldn't be asking that question anymore. But that wouldn't preclude us from necessarily asking other questions about constitutionality, other statutes, federalism. It's just that particular question would be removed from the table. So yeah, it would be different if if Congress had authorized it. Yeah. But that's not what happened. Yeah. Instead, the CDC has imposed a nationwide moratorium on evictions and its reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. Like those things. This is the and other stuff portion of the clause of the statute. Fumigation, pest extermination, and other stuff. When we say and other stuff, we mean other stuff like the stuff we mentioned. That's how that works. Bobby McBobface gave $2 to say late and share. Thank you, Bobby Mithrin Emrys says, the boomerang effect that's going to kick in once the moratorium is ended is going to be nasty. RIP housing market pretty much everywhere. Well, the CDC did a stupid thing that was illegal. So, yeah. It strains credulity, which is pretty big slam talk from the U.S. Supreme Court, by the way. Strains credulity is pretty, it's notable. Strains credulity to believe the statute grants the CDC sweeping authority that it asserts. It is non-credible. It is, in the literal sense, incredible. Yeah. In March of 2020, Congress passed the Coronavirus Act, Relief and Economic Security Act, to alleviate burdens caused by the burgeoning COVID-19 pandemic. Among other relief, the act imposed a 120-day moratorium for properties that were participated in federal assistance programs or were subject to federally backed loans. So Congress, when it was passing the original stuff in March of 2020, so long ago, said, okay, at least as it relates to federally backed loans, federally backed programs, we're going to institute a 120-day moratorium. A lot closer on the constitutional issues as well, by the way. So, yeah, a lot closer on the constitutional issues. So the U.S. Congress, in its infinite wisdom, said, here's a law we want to pass. I'm just a bill, only a bill, sitting here on Capitol Hill, right? And then they signed it and it became a law. Neat. That's how it's supposed to work. When the eviction moratorium expired in July, Congress did not renew it. Concluding that further action was needed, the CDC over here, who apparently decides that they're Congress somehow, decided to do what Congress had not. The new administratively imposed moratorium went further than a statutory predecessor, covering all residential properties nationwide and implementing criminal violations. So, this is a lot more suspect. It's not statutorily authorized like the other one, and because it goes to all property, not just federally backed property, it raises new constitutional concerns. There are some problems there. Starscream1540 gives me $5 and said, if the CDC did something bad and illegal, will the CDC go to jail? Sadly, no. No jail for the CDC. And we'll just have to accept them being beaten down as our gratification. The CDC moratorium was originally slated to expire on December the 31st of 2020. But Congress extended it for 1 month as part of a second COVID Relief Act. Okay, so basically what happens here is this is what we call ratification. Ratification, right? So the CDC might have done an illegal thing, but Congress can retroactively make things legal, right? It can't retroactively make things illegal. That is ex post facto. So it can't retroactively make things illegal, but it can retroactively make things legal. So Congress in December 2020, said, okay, ratification. We are giving our imprimatur to what has occurred. Now, this is distinctly not the same thing as saying it's legal, because they could have said that, right? They could have amended the relevant law and said it's legal. They didn't quite do that. They said, we're going to say we're okay with it, with what happened, and we're going to extend, which isn't quite the same thing as saying it's legal. That's another thing Congress can do. Definitely didn't do that, though. As the new deadline approached, the CDC again took matters into its own hands, because why do we need Congress extending the moratorium through March, then again through June, and ultimately through July? You know, not for nothing, but Congress kind of missed a step here, and I don't know if it was discussed, and I don't know if it was a thing of not getting it through in the legislation, but ideally, what Congress should have done is they should have said, we're going to retroactively ratify this, and we're going to make it explicit. You can't do this again. So we will, absolve you of the conduct, but we're going to make it explicit. You can't do it again. The you can't do it again language wasn't included in there. So there's nothing specific there. So I don't know if it's an issue of they didn't spot the issue, or, maybe the Democrats didn't want it in there for some reason. Who can say? But yeah, the Congress, it would have been slightly better if they had made an explicit mention of that in the relevant legislation when they were passing it. So the CDC again took matters in its hands, extending the moratorium through March, then through June, and then through July. Yeah. And then, of course, through September until October 1st, but not so much with that. The CDC relied on the statute for authority to promulgate. That provision states, okay, so we are all going to do statutory interpretation together. We're going to do our statutory interpretation together. We're going to read the statute Congress wrote. Good place to start. And we're going to see, what does Congress say? What do they want the CDC to do? What is the power? Let us consult the Holy Testament, the U.S. Code, and see what it has to say. And lo, the Surgeon General, with approval of the Secretary of Health and Human Services, is authorized to make and enforce such regulations as, in his judgment, are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into states or possessions, or from one state or possession into any other state or possession. For the purpose of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. All right, so there's all the language that we have. So let's break this up into a couple constituent parts. I'm going to provide you my explanation before we get to the U.S. Supreme Court's explanation, because I can. So we're going to hear the uncivil law explanation first. Have fun. All right. So first, we have this fairly broad thing that says the Surgeon General, with the authorization of the head of HHS, can make and enforce such regulations as is in his judgment are necessary to prevent introduction, transmission, or spread of disease. All right, that's fairly understandable, right? We understand this. Okay, the Surgeon General can pass regulation that, in his judgment, along with the HHS Secretary's judgment, are necessary to prevent introduction or spread of disease. That seems fairly clear. All right, let's press on. For purposes of carrying out and enforcing such regulation, the Surgeon General may. Okay, so we say the Surgeon General can pass regulations. But we didn't stop writing. We wrote more things. And there is a general presumption in law that when Congress writes stuff, it means things. We assume, unless Congress tells us otherwise, that they're not just randomly opining about stuff. Sometimes they randomly opine about stuff. Not usually in statutes, but it happens. So, short of that, though, we're going to assume every time Congress wrote something, it means something. Deep thoughts. So, they could have just stopped writing and said, for the purpose of preventing introduction and spread of disease, the Surgeon General can pass regulations to protect the health. Stop. End sentence. End section. Right? But we have more things. It says, for the purpose of this, the Surgeon General may do some stuff. Aha! Limiting principles. So how can the Surgeon General do this? Can he do anything? Well, he can do it by these mechanisms. Great. So what mechanisms can he do? Well, he can provide for inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated and other measures as in his judgment may be necessary. Okay. So then we have a whole bunch of stuff, specific things. For the purpose of this, the Surgeon General can do any one of these specific things. And then we list off a whole bunch of specific things. And then we end it with, and other measures as in his judgment may be necessary. Now, it is a canon of statutory interpretation. I am not inventing this. This is well established. It has a phrase in Latin, which I could look up to seem smarter, but no, I'm not going to look it up right now. But there is a canon of construction that says when you have a list of specific things, and the list of specific things ends with and other stuff, it doesn't mean all other stuff. It means the other stuff like the stuff we've provided in the list, right? Those kinds of things. So, for example, if there was a sign at the park and the sign said, no cars or trucks or other vehicles allowed in the park. By other vehicles, the sign does not appear to include wheelchairs or skateboards or bicycles, right? Those are all vehicles, or even maybe scooters, but we could have a debate. But, wheelchairs and skateboards, not that much like trucks and cars. So it doesn't mean all other vehicles. It means other vehicles like cars and trucks. And you can have a debate about what that means, but it doesn't mean all other vehicles known to man. Yeah. So in this section, when we say, and other measures, we mean other measures that are like inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles. So one of those things. Query, how is an eviction moratorium like any of those things? I can't figure it out. I don't know how an eviction moratorium is like any of those things. It confuses me. Originally passed in 1944, this provision has rarely been invoked, and never before to justify eviction moratorium. Regulations under this authority have generally been limited, quarantining infected individuals and prohibiting the import or sale of animals known to be transmitted. See, for example, this federal regulation, which banned small turtles who were known to be carriers of salmonella. So, yeah, apparently at some point in the past, thank you, Haley M, for the super chat and for the fox hugging a heart emoji. That's very nice. Thank you. So it's apparently at some point in the past, the CDC, unlike that 10-year-old boy in the infamous video who said, I like turtles. Apparently, the CDC, not the biggest fan of the turtles, and wanted to prevent the spread of specific small turtles who spread salmonella. Okay, fine. How is that like an eviction moratorium? Anyone got anything? John O'Brien gives me $2. Thank you, John. Concerned citizen. Where is the Constitution? Says any scooter, including 49cc gas-powered scooters, are not vehicles. I'm assuming, concerned citizen, that when you're saying that, that's referring to some statutory definition somewhere. I'm assuming that's in a statute or regulation of some kind that says that these kinds of scooters are not declared to be vehicles, but that's a matter of statutory construction, right? In my hypothetical that I created, all I knew is I have a sign at a park that says this. I don't know what jurisdiction I'm in. So I couldn't answer that question about like these kinds of scooters or not. Maybe there's a law somewhere that defines them to be vehicles or not. I'm just going off the sign. I'm just going strictly based on what the sign tells me. Cars, trucks, and other vehicles. So that's all I know is the sign. And the sign tells me, yeah. It definitely does not allow me to make a differentiation based on 49cc or 50cc. I'm pretty sure it doesn't allow me to make that fine a slice on that sign. Realtors associations and rental property managers in Alabama and Georgia sued to enjoin the moratorium. The U.S. District Court for the District of Columbia granted it because the district court can read. The court stayed its order pending appeal. It reasoned, though, even though the government had not shown a substantial likelihood of success, it did make a lesser showing of a serious legal question on the merits, which, fair enough, this would qualify as a serious legal question, where the government stayed warning, granting a stay when remaining factors are in the government's favor. Fair enough, a reasonable decision from the district court. Concerned citizen says it's Texas. Okay, in my hypothetical, I didn't say the park was in Texas, so. But, okay, noted, if you're in Texas, maybe you have to change your interpretation of what vehicles are. You're killing me. You're killing me. So the traditional 4 stay factors are whether the stay applicant has made a strong showing that he's likely to succeed on the merits, where the applicant will be irreparably injured absent a stay, whether issuance of the stay will substantially injure the other parties, and where the public interest is. That's the same 4-part standard. You probably should have heard of that before. This court declined to vacate the stay. It sure did. In an opinion that Justice Kavanaugh wrote, who was trying to, I think, be a little bit pragmatic and a little bit merciful, and then you decide to make him look like a fool. So that's annoying. So Justice Kavanaugh concurred, explaining that he agreed with the district court the CDC moratorium exceeded authority. But because the CDC planned to end the moratorium in only a few weeks, and because that time would allow for additional and more orderly distribution of funds, he concluded balance of equities justified leaving the stay in place. I know that there are people who disagree with this, but for my money, it's a reasoned decision from Justice Gorsuch. It's a reasoned decision from Justice Gorsuch. Because in this situation, an injunction is an equitable remedy. And we just discussed the four factors. Right? And reliance interest is part of that too. So I know there are some people who disagreed, but I thought Justice Gorsuch's opinion made total logical sense. It's like, this is illegal, they can't do it, but for better or worse, people have come to rely on it. It's set to expire in a relatively short time period. So let it expire. And let's all move on. A reasoned decision. I know there are a lot more people on the conservative side who want, no, end it right now. And some people are very unhappy with Justice Kavanaugh, but I'm like, okay, pragmatic, moderated, reasonable. I understand this. 200 rubles from a name I can't pronounce because it's in Russian. Great content. I enjoy Supreme Court cases. Thank you, person in Russia. I appreciate it. A man is a featherless biped. That's funny. Yeah, that's funny. Who was it who had the rebuttal? It was, oh man, I should know his name. Hold on, I'll come. Why can I not remember his name? He's a total badass, and he's one of the founders of Stoicism. He apparently said to Alexander the Great to get out of my light. What was his name? He said when people asked what to do with his dead body, he said, throw me over the walls with a stick, to which the people said, but you'll be dead. How will you be able to fight them with a stick? To which he apparently responded, if I can't use the stick, then what do I care what happens to my body? He apparently lived his life in a used wine barrel, and he threw away his cup when a kid asked him why he needed it, because he had hands. What was his name? Anyways, that guy, when Plato said a man is a featherless biped, he apparently stripped a chicken of all of its feathers and said, behold Plato's man. but I can't remember his name. Damn it. Diogenes. Yeah, I couldn't get there. It's like, I know everything about him, I can't remember his name. Can't remember his name. That's why I didn't want to open my eyes. I was doing the whole thing closed-eyed in case it would come to me, because I didn't want to be spoiled. Anyways. With the moratorium, okay. The moratorium, okay. Where were we? Okay. The moratorium expired on July 31st, 2021. 3 days later, the CNC reimposed it. They sure did. Apart from slightly narrowing the geographic scope to all the U.S. to 80% of the U.S., infecting 90% of the people, the new moratorium is indistinguishable from the old. Yeah, Diogenes. I got there eventually. With the moratorium once again in place, the plaintiff returned to district court seeking to vacate its stay. The district court agreed with the plaintiffs that the stay was no longer warranted for two reasons. First, the government was unlikely to succeed on the merits, given the 4 votes to vacate the stay in the court and Justice Kavanaugh's concurring opinion. Second, the equities had shifted in the plaintiff's favor. Vaccine and rental assistance distribution had imposed since the stay was entered, while the harm to landlords has continued to increase. But the court concluded that its history were tied by the law of the case in light of the D.C. court's earlier decision not to vacate, which again is a fairly reasoned decision for the district court. You know, the district court is actually correct in what it's doing here. As annoying as it is, though, but they're following the law. So the district court might want to do something else, but they can't. So what's the law of the case? Well, as the name sort of implies, every case creates its own law unto itself, right? That's kind of separate from all other law. So there's the law of the particular case. And in this particular case, the district court, under the broader one, said they can't do that. The D.C. Court of Appeals says, yes, they can. And the Supreme Court technically didn't say anything else. Technically. So now when the district court is faced with this thing, the district court makes the very reasonable conclusion. In fact, the correct conclusion, to be quite honest. The correct conclusion is, well, this eviction moratorium is exactly the same as the other one. There's no legal distinguishment. I mean, really. Like, oh, it's all the country versus 80% of the country infecting 90% of people. I can totally split that legally. District court's like, no, I can't. The district court's correct. You can't split it. So the district court's like, okay, it's the exact same moratorium legally. And I know that the D.C. Court of Appeals already said that I was wrong the first time. So I must be wrong. So I can't issue the stay. He's right. The district court's absolutely right. It can't. It's bound by the precedent of the D.C. Circuit. And the Supreme Court technically, very hyper-technically, didn't overturn that. So the D.C. Circuit's opinion is still binding precedent in the D.C. Circuit. So the D.C. district judge looks at this as like, can't do anything else. I can't issue the injunction. The D.C. Court of Appeals told me I'm wrong. It's exactly the same. That's still binding on me. Nothing I can do about it. The D.C. District Court's completely correct. Good on them. The D.C. District Court is by far and away the one that's most obeying the law in this situation. I just want to give props to the D.C. District Court. They're by far and away the one that most following the law. They have the best reason. They have the analysis that showed why it was illegal, and then they failed. And then they said we're going to stay our own order for reasons that make total logical sense. They're legally correct, and actually go along with my idea of nationwide injunctions by district courts are bad. So the D.C. District Court is by far and away the one getting this most right. So hey, props to them. D.C. Court of Appeals is full of it, man. Having passed through the lower courts twice, the plaintiffs returned to us to ask us to vacate. The district court concluded that the stay is no longer justified, and then said, but I can't do anything about it. So the Supreme Court says, we agree, validating the district court. You got it right. We understand that you couldn't do anything about it. We respect that, but we can. The applicants not only have a substantial likelihood of success on the merits, it's difficult to imagine them losing, right? Again, this is not like a hyper-complicated statute with really complex interchanging mechanisms. Like, for example, the Affordable Care Act, the last time it was up with the whole, state funding things, and Texas was suing, and there was a clause there about what states can do and a clause there about what the federal government can do. And there's all this kind of interplay language that's all kind of interrelated. It's like, geez, does this section mean the federal government can't do it? Does this section mean that they can? Legally complex analysis involving multiple different sections and their interrelations. So regardless of whether you think that they came up with the right answer or not, ultimately, it was a complex legal question. This one's much less complex. It's 2 sentences long. We read it. We're there. The government contends the first sentence gives CDC broad authority to take whatever measures it deems necessary to control the spread, including moratorium. And this is kind of why this doesn't work, because, again, we presume that everything Congress writes means something. And if Congress wanted the CDC to have all the power of the first sentence read alone, then why didn't they stop writing? Right? I mean, Congress clearly knows how to give the CDC unlimited power if it wants to, because apparently it did that in the first sentence. So it knows exactly how to do it. Why did it keep writing things? Do those other things not mean anything? That kind of goes against the presumption, particularly when the other things are, here are the mechanisms by which he can do that, and it's exactly the next sentence that follows. This reminds me a little bit of a joke from The Simpsons when the school struck oil, and there was a headline published in the Springfield newspaper that said, "Awful school is awfully rich." And when Principal Skinner was showing it to the superintendent, he covered up the first "awfully." So it just says, "School is awfully rich." And the superintendent says, you appear to be covering part of the headline. And the Skinner says, "Oh, it's an unrelated issue." And the superintendent says, "It's an unrelated issue within the banner headline of the article." And Skinner just says, "Yes," and hides the newspaper. Good joke. Reminds me of that. It's like, yeah, this second sentence has nothing to do with the first sentence that immediately precedes it. It's a completely unrelated sentence within the same breath. Yes. Principal Skinner would be proud. Maybe Principal Skinner works for the CDC now. That would explain things. So the government argues the sentence 1 gives us all the power, but the second sentence informs the grant of authority by illustrating the kinds of measures that could be taken. Yeah. Inspection, fumigation, disinfection, sanitation, pest extermination, and destruction of articles and animals. Right. These measures directly relate to preventing the interstate spread of disease by identifying, isolating, and destroying the disease itself. Correct. The CDC's moratorium, on the other hand, relates to interstate infection far more indirectly. If evictions occur, some subset of tenants might move from one state to another, and some subset of that group might do so while infected with COVID. This downstream connection between eviction and interstate spread of disease is markedly different from directly targeting the disease that's characterized by measures identified in the statute. I am very pleased that the Supreme Court recognizes the difference between direct things and indirect things, and recognizes the CDC has been given power to do direct things, but not indirect things, particularly when those indirect things are several steps down a chain of causation. So the direct things, yes. The indirect things, particularly more attenuated they become, less proximately caused, one might say, not so much. Now, anyone who watches this channel for any length of time should be able to determine what the next sentences out of my mouth are going to be. I've been saying this deliberately for some time now because I'm going to say something next. Who in the channel knows what's going to be next? I'll give you 5 seconds to figure it out. I wish the Supreme Court would have applied that same logic when it comes to the Interstate Commerce Clause of the Constitution. That logic would have been real helpful in Wickard v. Filburn, when we dealt with interstate commerce and the ability of the Congress to regulate interstate commerce. Really direct things like, for example, tariffs between states. That would be an example that we can't do that. Or direct restrictions on products, can't do that. Really direct things, yes. But the more attenuated things, like, for example, a farmer growing wheat on his own farm for the purposes of feeding his own family and his own livestock, maybe too indirect, maybe too attenuated. Would have been really nice if the Supreme Court had had that idea when they were discussing Wickard v. Filburn. Who got it right? Even if the text were ambiguous, the sheer scope of the CDC's claimed authority under Section 361A would counsel against the government's interpretation. We expect Congress to speak clearly when authorizing an agency to exert powers of vast economic and political significance. That is exactly the kind of power the CDC claims here. At least 80% of the country, including between 6 and 17 million tenants at risk of eviction, fall within this moratorium. While the parties dispute the financial burden on landlords, Congress has provided nearly $50 billion in emergency rental assistance, a reasonable proxy of the moratorium's economic impact. It's not clear that economic assistance has incidentally gone to the landlords, right? It's the economic assistance goes to the tenant who's supposed to use it to pay the landlord. Has that been happening? Yeah. KM, if I give you a question like that, it's probably Wickard v. Filburn or it's probably Chevron. Probably one of the two. Because I'm infamous for ranting about those cases at any possible opportunity. Our precedents require Congress to enact exceedingly clear language if it wishes to significantly alter the balance between federal and state property and the power of the government over private property. Indeed, a government's read of 361A would give the CDC a breathtaking amount of authority. Yeah, it's hard to see what measures this interpretation would place outside the CDC's reach, and the government has identified no limit in it beyond the requirement that the CDC deem that measure necessary in furtherance of the public health. Now, query. Can you think of anything that if the CDC really put their thinking hats on, would be unable to in some way say, this measure is necessary to protect the health? Is there anything that they couldn't do if that was the standard? A regulation that clearly wouldn't work if the standard was anything that they think is necessary to protect the public health. Do you think there's anything they couldn't somehow justify as protecting the public health? Because I don't. I think they could justify everything by putting their thinking hats on if they really wanted to. Could the CDC, for example, mandate free grocery delivery to homes of sick or vulnerable? Sure. Require manufacturers to provide free computers to enable people to work from home. Why not? Or telecommunication companies provide free high-speed internet to facilities to facilitate remote work. Sure, that sounds like a thing. Those all sound like good examples. This claim of expansive authority under 361 is unprecedented, and also, incidentally, would probably be unconstitutional because it would probably be a delegation of legislative authority, which Congress can't do. So, yeah, there's that too. So, it would be unprecedented and probably unconstitutional. Since the provision's enactment in 1944, no regulation premised on it has even begun to approach the size or scope of this moratorium. So, maybe it's because I'm conservative, and maybe it's because I'm Republican, but I can't think of anything the Trump administration did that even began to try to go this far beyond the text. I can't think of anything they did that went this far beyond clear text. And this power grab is just insane. It's insane. The problem is here, it's a well-defined statute. Like, even in the situations where Trump kind of went too far, he went too far in situations where the statutes themselves were broader or vaguer. So it didn't quite have this collision problem. He wasn't colliding against something this clear. But this is clear, and the Democratic Biden administration, the CDC, has just basically appointed themselves emperor over here. What if this, it doesn't make any logical sense. It doesn't make any sense at all. The claim is unprecedented. Since the provision's enactment, no one has done anything close to this, and further amplified by the CDC's decision to impose criminal penalties of a $250,000 fine and 1 year in jail. Section 361A is a wafer-thin reed on which to rest such sweeping power. Yeah, I mean, every canon of construction tells you this is correct. Like, every legal principle that I can think of holds this is correct. You have a specific list followed by and other things. We know how to interpret the other things. This second sentence comes immediately after the sentence saying the CDC director, the Surgeon General can do things, and here's the things they can do. So it's this way from statutory text. Even if you were reading the first sentence alone, you wouldn't read it that expansively because Congress probably didn't mean that. So even if you have the first sentence lying alone, to have the constitutional avoidance problems, you'd probably say Congress didn't mean that literally, because if you read it literally, you'd have constitutional problems. So because courts try to avoid it when they can, they probably say Congress probably didn't literally mean that. And if they said Congress did literally mean that, then you have constitutional problems up the ass. Delegation of legislative authority and the Fifth Amendment come notably to mind. Also, because we're arresting people, the Fourth Amendment. So, yeah, we're just get a constitutional trifecta here. Delegation of authority, delegation of legislative authority, Fourth Amendment, and Fifth Amendment. That's just great. That's just great. The equities do not justify depriving applicants of the district judgment in their favor. Yeah. The moratorium has put applicants, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent with no guarantee of eventual recovery. Despite the CDC's determination that landlords should bear a significant federal financial cost of the pandemic for some reason, many landlords have modest means. Yeah, not every landlord is a uber-rich mega corporation. There are a lot of mom-and-pop landlords. There's a lot of people basically using it as part of their retirement income. A couple properties, they have someone else manage it. Not everyone is BlackRock. Yeah. So, yeah. Despite the CDC's determination landlords should buy at a significant cost, many landlords have modest means. They sure do. And preventing them from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, the right to exclude. Right? Like the bundle of sticks. I don't know if your law school used this example, but mine sure as hell did repeatedly. Talk about property rights as a bundle of sticks and the things that go into the bundle. I'm debating right now whether or not to use a very specific word for a bundle of sticks because I can, but I think the algorithm would not be happy, so I'm going to avoid it, even though it would be technically correct. We'll just call it a bundle of sticks. Anyways, the bundle of sticks includes things like the right to sell property, the right to lease property, the right to share property, the right to destroy property, the right to sell property, the right to loan against property, the right to alienate against for property, the right to exclude, and so forth and so on. Yeah, so all those things. Yeah, and A. Hedinger is quite right. After this, there may not be as many mom and pop landlords as there was at the start. As harm to the applicants have increased, the government's interests have decreased. Since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transition away from the moratorium. Whatever interest the government had in maintaining the moratorium's original end date to ensure the orderly administration of those programs and system diminished. Lance Pierce gives me $10. Hello, Lance. Thank you for being part of the channel. Really appreciate it. Filed 16 evictions today. The payments are made directly to the landlord, but take months assuming the tenant actually does the paperwork. Fair enough. Yeah, I don't know if you'll be able to have those. The whole moratorium was in processing the evictions. It never prevented people from filing them. But in terms of them being processed, it probably is the case that the federal district courts will have to implement this on a district level. So the Supreme Court has spoken, and now the district court has to release each district from the stay. It'll be interesting to see if there's a district court that tries to defy the Supreme Court, because that's the only way this can get more hilarious. Because there's like 100, how many district courts are there? 92? Something like that. So it'll be interesting if, or maybe it's either 92 or 114, one of those two. But it'd be interesting if one of the district courts tries to defy the Supreme Court and won't issue the order. That should be real hilarious. Yeah. Will a district court go rogue? Thank you for the super chat again. Congress was on notice. The further extension would almost surely be requiring new legislation, yet failed to act. And then said, oh, we can't get our shit together, so CDC do it for us. And then the CDC said, no, we can't. And then said, oh, wait, yes, we can. When Obama said, yes, we can, I'm not sure he was saying, yes, we can defy clear law and, ignore the clear import of orders. But apparently that was the memorandum you guys got somewhere along the way. It's indisputable the public has a strong interest in combating the spread of COVID-19, but our system does not permit agencies to act unlawfully, even in the pursuit of desirable ends. Truth. It's up to Congress, not the CDC, to decide where the public interest merits further action. If a federally imposed eviction moratorium is to continue, Congress must specifically authorize it. The application to vacate the stay presented to the Chief Justice and by him referred to the court is granted, so ordered. So, yeah, all those things. MC gives me $15 to... I'm trying to see what this is. Oh, it's beer. It's 2 beer glasses chinking together. Thank you, MC. I will use your $15 to bring some beer glasses together in the near future. I appreciate you supporting my beer habits. You are awesome. Thank you. Okay, so now let's read some dissent who are going to be complaining about, oh, we just needed more briefing. We needed more time. Justice Breyer, with whom Sotomayor and Kagan joined dissenting. I am slightly disappointed, although not surprised, that Kagan is in dissent. Kagan sometimes can be pretty reasonable. So I'm saddened a little bit to see. Here's what they have to say. The Centers for Disease Control and Prevention has issued orders that, in light of the rise of COVID-19, temporarily prohibits certain evictions in high transmission counties, which, again, is 80% of them. Today, this court, as an emergency matter, without fully briefing or argument, blocks that by vacating the lower court stay. I think the court is wrong to do so, and I dissent. Okay. We may not vacate a stay entered by a lower court unless that court clearly and demonstrably erred in its application of accepted standards. Well, the district court put it in because it realizes its own limitations and is humble. The Court of Appeals put it in because they're idiots. The accepted factors are the factors we quoted above. We don't need to say them again. In my view, the courts below did not err for 3 reasons. Okay, sell me. First, it's far from demonstrably clear the CDC lacks the power to issue its modified moratorium order. Okay. It's apparently not clearly demonstrable. So it's apparently not clearly demonstrable the second sentence exists, or that Congress meant it as a limitation, so why did they write it? Or something. But it's not demonstrably clear by reading. The The CDC's current order is substantially more tailored than its prior eviction moratorium. You and I have to have a talk about what substantially means. That's what I feel right about now. You feel this is substantially different? Okay. Even in its either in its sort of common meaning or its literal meaning, is it substantially? In its common meaning of substantially, it means basically that it's a lot, like of substance is the more common meaning. But more legally precisely, substantively means that it's substantive in that it makes a difference. There's something of substance, right? There's something of substance. So it doesn't have to be a lot. It just has to be of substance. It has to have materiality to it. So either way, how are you getting substantially different? It's obviously not in terms of it being a lot. And even in terms of its more narrow legal definition of substantially being of substance. What of substance? It went from 100% to 80%. And that matters because why? Like, it's different, but it's different because why? In a way that's substantive, as opposed to like just technical. Why is, in our sort of like biological classification, why is this thing different from this thing? In a way that matters. Yeah. But apparently they think it's substantially more tailored. We have to have a discussion about substantively. Justified by the Delta variant surge, the modified order targets only those regions currently experiencing skyrocket rates, which is 80% and 90%. Yeah. If a covered county no longer experiences substantial or high levels, the order will no longer apply there. To illustrate the difference, when we denied applicants' last motion, fewer than 20% of counties would have been covered under the modified order. Today, the figure is over 90%. What? Okay. To be protected from eviction, a tenant must reside in a covered area, which, as you just said, is 90% of people. And attest that he or she has been used best efforts to obtain all governmental assistance for rent or housing, satisfies certain income requirements, is unable to pay rent due to substantial loss or household income, continues to use best efforts to make timely partial rent payments, and has no other housing options. I would like to point out that all the people who have been signing these things have been doing so under penalty of perjury. So, query, what's the possibility that an administration will prosecute some of these people? Because, I'm sure some, and maybe most, maybe nearly all for that matter, there's many people I'm sure who can honestly sign off on all 5 of these things, but I think it might be possible, and bear with me. But I think it's possible some people may not satisfy all 5 of these. In fact, I think it's possible that people know they don't satisfy all 5 and might have signed anyway. I know. Someone might have lied to the federal government in order to get money. But I think it's possible. I wonder if any of those people will be prosecuted, assuming they exist. Unlike New York's moratorium, the landlords remain free to challenge in court the truthfulness of a tenant's declaration that he or she qualifies for order protection. The CDC issued this modified moratorium order, like its prior moratorium, pursuant to its powers under the Act. The Act says the thing that we already said, so we won't say it again. The statute's first sentence grants the CDC authority to design measures that, in the agency's judgment, are essential to contain disease outbreaks. Read by itself, sure. The provision's plain meaning includes eviction moratorium necessary to stop the spread of COVID-19. The first sentence, sure. When Congress enacted this law, public health agencies intervened in the housing market by regulation, including eviction moratorium, to contain eviction by preventing the movement of people. Well, I thought, but okay, this doesn't make sense. Something here is not making sense and not quite squaring. Because You say when Congress enacted it, public health agencies intervened in the market by doing this. But the majority said this language was from 1944. But you're citing 1920 newspaper article. So when do you think the statute went into play? You never say, incidentally, or you haven't said, yeah, you haven't said. So the majority said in its decision, this came into effect in 1944. So what a newspaper wrote in 1920 can't really speak very highly to something that occurred in 1944, right? So what do you think when do you think the statute was passed? Or do you think there was some other statute that they were using? What is your basis for thinking that what the CDC did was legal in 1920? The fact that it happened? You're not flushing it out here. Yeah. You say when Congress enacted this statute, public health agencies intervened to contain the infection by including eviction moratorium. So you're saying when Congress enacted this law, public health agencies put in place eviction moratorium, and then you cite an article from 1920, even though the majority says the law wasn't passed till 1944. And you don't say when it was passed and that there's a problem here. When do you think okay. Section 361A, second sentence, is naturally read to expand the agency's power by providing congressional authorization to act on personal property when necessary. What? Okay. How do these two thoughts square? I'm going to read the first sentence of the first paragraph on screen, and then I'm going to read the first sentence of the second paragraph on screen to see if these two thoughts square, because I don't think they do. The statute's first sentence grants the CDC authority to design measures that, in the agency's judgment, are essential to contain disease outbreak. Section 361, second sentence, is naturally read to expand the agency's power by providing congressional authorization to act on personal property. Query. If the second sentence expands on the first, expands on the powers of the first, then what power is not contained in the first sentence? Right? That's the only way this makes sense logically. The only way for this to logically make sense. You can't say that Section 361A's second sentence expands agency power unless that power is not in the first sentence, right? It can't expand it if it's already there. Can we agree on this much? The second sentence expands power. In order for it to do that logically, this first sentence doesn't contain the power. That's what makes it an expansion, like DLC, right? Or an expansion pack of a computer game, right? You download the DLC, and it does more things, right? It does more things than was in the original. If you downloaded a DLC or an expansion pack and it didn't do more stuff, if the game was exactly the same after you downloaded and paid for the DLC, you'd probably be a bit salty, right? It's like, I paid for an expansion. This expansion does literally the same thing that was already in the base game. I'm a happy customer. Those two thoughts don't really go together in the same breath, right? So in order for the second sentence to logically make sense, it must mean the first sentence doesn't contain some kind of power. Okay, so going back to this first sentence of this first paragraph, The statute's first sentence grants the CDC authority to design measures that, in the agency's judgment, are essential to contain disease outbreak. Query where the limitation is in that first sentence. I mean, to contain disease outbreak, but that's the only limitation. The second sentence doesn't change that limitation. It just says, oh, by the way, personal property. So where is the limitation in the first sentence? Where is the limitation in power in the first sentence that the second sentence expands that power? Where is the limitation and limit of power in the CDC can do anything it wants in order to prevent the spread of disease? And oh, by the way, here's some more power. You can also do some things with respect to personal property. $5 from Ricardo Ospinilla. Sorry I missed the first part of the stream. Why did Roberts flip? No idea. Was it because the CDC promised to extend and not then lie? No idea. He didn't say. So, fair enough. So we got a logical fail in here somewhere. The CDC's apparently the second sentence somehow expands the unlimited power. I think I had an interruption in my stream there for a second. Okay. C, whatever. It could also be read to provide emphasis regarding particular enforcement measures. Oh, emphasis. You can do everything. But just to emphasize the everything, here's some specific examples of everything. Yeah. Applicants urge in today's per curiam agrees the second sentence should be read to cabin the CDC's authority. Not only does that reading lack a clear statutory basis, but the second sentence goes on to empower the CDC to take other measures as in its judgment may be necessary. Okay. Okay. So the dissent here apparently is somehow unaware of the canon, which I'll look up what it is in Latin. Just, I can do this in Supreme Court speak. Hold on a second. Hold on. Now, this may not be good Latin, but we're going to try to do it anyway. Okay, so this is not going to be good Latin, but the Latin phrase is Estium generis. Es justium generis, maybe? Es justium generis. I'll just put it in the chat so you guys can debate on the pronunciation among yourself. But yeah, there's this basic canon of statutory construction that's older than dirt that basically says when you say and other stuff, it means of the same class. And apparently the dissent over here somehow is unaware of this and says it literally means all the things. So they've violated a provision of statutory interpretation that is so old, I don't even know if anyone knows when it started. That's how old it is. I'm not sure that anyone can point to a start date. The where this came up with is lost to legal history. It's so freaking old. But apparently they don't know that for some reason. Eusdium generis, Eusdium, Eusdium. Whatever, you guys know what it is. It's fine. There's a bonk emote in there somewhere. It's not necessarily me. Eusdium. Yeah, there's an emote in there somewhere. Yeah, hold on. Furthermore, reading the provision's second sentence to narrow the first would undermine Congress's purpose. Really? As a key drafter explained, the second sentence of subsection A was written not to limit the broad authority contained in the first sentence, but to expressly authorize inspections and other necessary steps in the enforcement of the quarantine. But if it can already do everything, then why say it? Okay. The per curiam also said that Congress must speak more clearly to authorize. But it's undisputable that the statute permits the CDC to adopt significant measures such as quarantines. Yeah, that's in a different section of the law, but yes, they can do that. Which arguably imposes greater restrictions on individual rights and state police powers than do limits on evictions. Maybe, maybe not, but it's an express power that they have. So, yeah. Indeed, the current Congress did not bristle with the government's reading of that statute. In 2020, Congress extended the moratorium issued under the section. They extended it for a time, and then it stopped being extended. In any event, lower courts have split on this question. See, for example, the Court of Appeals for the DC Circuit, which is full of shit, with Tiger Lily, with the Court of Appeals for the Sixth Circuit, which was not full of shit. Given the split among the circuits, it's at least hard to say the government's reading the statute is demonstrably wrong. The DC Court of Appeals is full of crap. At a minimum, there are arguments on both sides. There really aren't. I know you guys want to pretend there are because Lawrence Tribe over here is saying, it's totally okay. And the DC Court of Appeals somehow has their head right up their ass. But it's just, no, it's just not. This isn't one of these questions that's really closely divided, and it's not really sure what the right answer is. That does happen. They happen all the time. I've been on stream more than a few times when we've done Supreme Court Reacts, where we've done live streaming of oral arguments. And I've more than on a few occasions said, I don't know what the answer is. Right? I don't know what the answer is. This argument, like the one that, for example, comes to mind, although it's not necessarily the most recent, but it's one that comes to mind, was the situation where a U.S. border agent, I think, doesn't really matter, some U.S. government official of some variety shot a Mexican who I think they thought was illegally immigrating and whatever. But most critically to our analysis was actually in Mexico at the time. So, yeah, the border patrol agent or whatever it was apparently unclear where the border begins. And I think it was a fairly young kid, too, just to add insult to injury. I think it was under 18. It might have been even younger than that. I forget exactly. But this border patrol agent shot a gun across the border and struck a kid and killed them in Mexico. So there was a really good question under the law about, hey, wait a second, the primary question wasn't even 1983. The primary question was, hey, wait a second, does the Fourth Amendment apply? And the reason you ask that question is because there's lots of case law that says when U.S. government officials are participating in overseas operations, the Fourth Amendment does not apply. So assuming they have, not even assuming, it doesn't matter either way, but hopefully with the permission of their government, of the government of whatever country, if they kick down the door, the Fourth Amendment doesn't apply, the Fifth Amendment doesn't apply, etc. and so forth, right? because our country's laws only protect us. And the U.S. government official doing that in some other country, well, that doesn't protect you. So we knew that one. So we were in this situation. So we know if he kicks in the door in Mexico, the Fourth Amendment doesn't apply. We know if he shoots someone in Mexico, the Fourth Amendment doesn't apply. But then the question is, okay, wait a second. Does the Fifth Amendment apply? Does the Fourth Amendment apply when he's on our side of the border shooting at someone in their side of the border? See, that's a really good question, right? Because we know if they're both standing on our side of the border, the Fourth Amendment applies. We know if they're both standing on the Mexican side of the border, it doesn't apply. And then the question, hey, wait a second. One of them is on our side, one of them is on their side. Does the Fourth Amendment apply or not? See, we don't know the answer because we're in neither of those situations. And it's like, I don't know the answer to the question. It's a really good question. Incidentally, for the record, the answer was it doesn't apply. But there was no way to know that, at least obviously to my mind. I mean, I think it came out, it might have been unanimous when it came out. I can't remember, but I don't remember being sharply divided. But even if it was unanimous, the answer wasn't inherently obvious. I'm looking at this like, I don't know what the answer is. I don't know. I know what the answer if they're both standing on that side of the border. I know the answer if they're both standing on this side of the border. I don't know the answer to this question. So it wasn't one of those things where, geez, I just don't know. There's good arguments. There's policy arguments. I don't know. This was a lot easier for me to figure out. It wasn't that. It wasn't that. Grey Knight says it does apply. It just doesn't apply because imperialism. Well, for whatever it's worth, I don't remember the word imperialism being anywhere in that decision, but sure, you do you. Please completely ignore the rationales of the courts that have struggled with these issues and try to apply the law. Please just ignore all that and just say it's because imperialism. Sure, that's fine. Certainly this court did not resolve the question by denying applicants' last emergency motion, whatever one justice might have said in concurrence. The scope of the challenge moratorium, the balance of equities and public interest were all different. Really? Were they, though? As is typical in this court's emergency order denying extraordinary relief, we said most nothing about the reasons for declining to act. Well, that much is true. They usually don't specify why. Second, the balance of equity strongly favors leaving the stay in place. Applicants say they've lost thousands of dollars in rental income. That injury is lessened by the moratorium's order directed that tenants have an obligation to make as close to the full rent payment as possible, which I'm totally sure that all of them are doing. They're doing their absolute best to give the landlords everything they can, right? And to compensate for that shortfall, Congress has appropriated more than $46.5 billion to help pay rent. It may, as applicants say, take time to get the money, and that is an injury. But comparing that injury to irreparable harm from vaccinating to stay, COVID-19 transmission rates have spiked in recent weeks, reaching levels the CDC puts as high as its last winter, 150,000 new cases per day. And then we have a trend of COVID-19 because that should influence the legality of it, right? I mean, if it's really, really serious, then that's one interpretation of statute. But maybe if it's not really serious. So if the CDC today were to put in order a eviction moratorium for, I don't know, what's a disease that kills very few people? How about consumption? That sounds good. If the CDC put in place an eviction moratorium in order to stop consumption, that comes out differently than eviction moratorium for COVID because COVID is just way, way more serious, and therefore the law changes? Drywall dust. Do I have drywall dust on me? I don't see any, but all right. Mine bought a new car. See, Mary, you weren't supposed to do that. Mary, didn't you know the regulation says you're supposed to pay the landlord as much as possible? You weren't supposed to use the money to pay rents. I mean, maybe you didn't maybe you didn't know that regulation. Maybe you didn't get it in the memorandums that you were supposed to use that money in order to pay your landlord. I'm sure it's a simple mistake. Yeah. To date, CDC estimates that 38,150,911 Americans have been sickened. 629,139 have died. This week, the CDC calculates average new daily hospital admissions at 12,209. The number of patients hospitalized with COVID-19 is up 13.3% from last week. For whatever it's worth, you should probably get vaccinated. Yeah. Look back at the order's criteria for temporary eviction relief. The CDC targets only those people who have nowhere else to live in areas with dangerous levels of community transmission. You know, I think I have a sneaking suspicion. I have a sneaking suspicion that all these people who have sworn under oath they have nowhere else to go, a great many of them will find somewhere else to go. Just guessing that maybe some of them lied. You took out an emergency loan to get Bitcoin? Well, you've been doing well because Bitcoin's up like 100% or something, so good for you. Look back at the order's criteria for temporary eviction. The CDC targets, yeah, we read that. Absent the current state, the CDC projects a strong likelihood of mass evictions nationwide, which, you know, with public health consequences that would be difficult to reverse. Third, the public interest is not favored by the spread of disease or court second-guessing of the CDC's judgment. We're not strictly speaking second-guessing their judgment. We're second-guessing their power. We're not second-guessing that it's a good idea. We're second-guessing that they have the power to do that. The CDC determined a surge in evictions could lead to immediate and significant movement of large numbers of persons from low density to high density. But I thought those people had nowhere else to go. What do you mean? What do you mean a surge in evictions could lead to immediate movement from low density to high density? Wait a second. Whoa. What do you mean, CDC? What do you mean that this would cause people to move from low density to high density? What do you mean? Because after all these people, all of them, have said under penalty of perjury, I have nowhere else to go. So what do you mean, CDC? You are projecting they'll move from low density to high density. They can't possibly do that because they have nowhere else to go. Don't you remember? CDC, don't you remember? Are you saying that you think a lot of people are lying? Are you saying, CDC, that you think a lot of people are lying to your face? Are you saying that you believe that massive numbers of people are committing fraud against the U.S. government and lying? Are you doing anything about that? Because apparently you think people are going to move, even though they swore they can't. Right? I mean, I'm not just making this shit up, right? $5 from Lance Pierce. Solution: evicted tenants must quarantine or be vaccinated, using the same logic. You'd be closer. Yeah, you'd be closer. Why not? Why not? Yeah. You'd be a lot closer. Why not? The CDC cites models showing up to a 30% increased risk of contracting COVID for some evicted people and those who share housing with them after displacement. Died Najeez wasn't a stoic, he was a cynic. Fair, Peter. Fair enough. Thanks for the $10. I don't know. He might have been both. Yeah, I don't know. He might have been both. But fair, he was definitely a cynic for sure. Yeah, but he might have been both. A lot of what he says seems pretty comparable with Stoicism. But, okay. Just, we can have a debate in Philosophy Tube some other time. The CDC invokes studies finding nationally over 433,000 cases and up to 10,000 deaths may be traced to the lifting of this moratorium. The public interest strongly favors respecting the CDC's judgment when over 90% of counties are experiencing high transmission rates. That figure is the highest it's been since last winter. It was in the single digits when we considered the CDC's previous moratorium and denied that relief. On applicants' last trip to the court, they argued the downward trend in COVID-19 cases left no public health rationale for the CDC's moratorium. These predictions have proved tragically untrue. Today showed just how little we may be presumed to know the course of the pandemic. Applicants raised contested legal questions about important federal statutes on which lower courts are split because the D.C. Court of Appeals is full of it, and which this court has never actually spoken. These questions call for considered decision-making, informed by full briefing and argument. These answers impact the health of millions. We should not have set aside the CDC's eviction moratorium in the summary proceeding. The criteria for granting it are not met. I respectfully dissent. Well, fine, Justice Breyer. That's just great stuff. Yeah. The Streamlabs doesn't get the joke. Streamlabs doesn't get the joke. CDC. Yeah, 2 weeks to flatten the curve. 2 weeks to flatten the curve. Exactly, stuff. Exactly, so. Yeah. So that brings us to the end of this discussion of this thing. So, as I was sort of indicating up front, I think it's true that the district courts will have to collectively issue the orders for their respective districts, and it will be hilarious to see if a district court doesn't do that or drags its feet in light of the clear order from the Supreme Court. How defiant do we want to get today? That'll be if some district court goes well off the reservation, we'll cover that for sure. That'd be hilarious. Peter says separate philosophical beliefs. Stoic belief is mentally can overcome attachment. Stoics believe in total aestheticism. Okay. Well, all right, fair. Hold on, I'm getting something. Let me see if this is relevant to what I'm trying to do. Hold on 1 second. Oh. Apparently someone shouted me out. Who shouted me out? How to cook that. Oh, that's nice. How to cook that shouted me out. So I did an analysis of how to cook that with the legal issues, and apparently she shouted me out. So she's a channel with 4.7 million subscribers. So apparently she shouted me out, and she shouted me out before Legal. Whoa. So if anyone from the How to Cook channel wants to come over, let me know. Yeah, that'd be great. So apparently the How to Cook people. So we need to do a cooking stream, I guess. So the next thing from Uncivil Law will be a cooking stream, which I assure you will go poorly. We'll try to make a cake. It won't go well. It'll be hilarious. But that's great. Awesome. Sweet. Anyways, that's all we have for this particular stream. Tomorrow or Monday, I'll be trying to deal with this border issues with that, because that's also hilarious. Yeah. So all that stuff. So we'll see. As always, I hope you liked this video and you enjoyed the legal education comment and commentary, and also apparently a discussion on philosophy and what Stoics and Cynics stand for respectively. Interesting. I wish I'd taken more philosophy classes in school. I just wish that was an oversight in retrospect. If you're enjoying this stream, please remember to give it a like. If you're not subscribed already, give it a subscribe. And did you know for 99 cents, you too can become an uncivilian? It's true. By hitting the join button or hitting the link that Streamlabs tells you about from time to time, you can become part of the channel financially. And for a mere 99 cents, you get a cool little icon by your name, like Pierre does, Pierre does and Peter does. You get a cool little icon by your name, and A. Hedinger does. You get these cool little icons to show your love. It's great. So please do that, and please do all the YouTube-y things. Share on Facebook, Twitter, blah, 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 all the rest of it. So until later, my friends, I hope all is well. Cheers and goodbye.